All right, we're back on record. State versus Alan Shoemaker.
Do you know an Alan Shoemaker?
Yes, I do.
And how do you know Alan?
We were married for 36 years.
At some point, did you file for divorce?
Yes, I did.
When was the divorce filed?
In June of 2019.
Was the divorce amicable? Did everyone get along?
No.
Why is that?
Well, Alan didn't seem to accept that we would be divorced, so he fought it.
Did you file a CPO against the defendant in 2023?
Yes, I did.
Why is that?
Well, because I was receiving mail that had what could be seen as threatening content.
Around September 17th, 2024, did you receive mail?
Yes, I did.
Do you recognize the writing in that letter?
Yes, I do.
And whose writing is it?
That's Alan's writing.
Is there a Mary Grace reference?
Yes, there is a Mary Grace reference.
Do you know a Mary Grace?
I do not.
Has he ever sent other letters in care of a Grace Shoemaker or a Mary Grace Shoemaker?
Yes, he does.
Does a Mary Grace Shoemaker live with you?
No.
After you received this letter, what did you do with it?
I took it to the sheriff's department and filed a complaint.
Around September 30th, 2024, did you receive mail?
Yeah,
Where did you receive your mail?
at my home address.
After you received this letter, what did you do with it?
Took it to the sheriff's department to file a complaint.
Gotcha. Around May 1st, 2025, did you receive mail?
Yes.
Among those names, there is an Angie Roush. Do you know who that is?
Yes, she was my supervisor at work.
Work?
Mhm.
Is that... There's also a Teresa Rhodes. Do you know who that is?
Yes, she was my coworker.
And to your knowledge, is there any connection between your children and either Angie Roush or Teresa Rhodes?
No.
When you received this letter, did you understand it to be intended for you or your household?
Yes.
And then after you received it, what did you do with it?
I took it to the sheriff's department to file a complaint.
On June 18th, 2025, did you receive mail?
Yes.
And what does that letter specifically say about Dr. Drew?
Give Miss Collins Dr. Drew's information.
To your knowledge, was the defendant aware that you were seeing Dr. Drew?
Yes.
And then after you received it, what did you do with it?
I took it to the sheriff's department to file a complaint.
No further questions.
All right, Mr. Shoemaker, if you wish to ask the witness questions, you may do so at this time. Stand at the lectern, please.
You received those letters.
Correct.
And you opened them?
No.
You didn't open them?
No.
You gave them to Ethan?
Yes.
And then he gave them back to you?
He came to the house and he opened them and read them and left them at the house.
Okay. Did he ever receive any other mail at that address?
Yes.
So that was an address where he had told me that if I needed to get a hold of him to send letters to that address.
Objection.
Also stating that you're not permitted to testify at this point. You have to ask questions.
Right. Where do you work? Okay, what is that? What does it do?
Objection. Relevance.
I'll allow that question. We're not going to go too deeply, but she can answer that.
We're a computer distribution and configuration center.
And that company has a tech department.
Correct.
And what does that department do?
Objection.
Okay, I'll sustain that. That's not relevant.
When I was in Madison, I took a year of computer classes. In that class, you can take a copy of a letter.
I'm going to object. This is...
Okay, I'm going to sustain that. You're not asking a question, you're testifying. So the jury will disregard that.
The purpose of the tech room is to set up computers to make them work like the customer would like them to work.
Objection, Your Honor. This is not relevant to the charge.
I'm going to sustain that. There's no relevance here. So move on to something else.
Okay. I guess at this time I have no further questions. Like to call Michael Johnson Sr.
Michael Johnson Sr.
Correct. And where do you reside at this time?
Lake Erie Correctional Institute.
And this is where we met?
Yes.
How close were we?
Side by side in the same cube, bottom racks, here right across from me.
We basically went pretty much everywhere together. We went to the chow hall.
Objection,
together.
he's testifying.
Yeah, that's called leading. You're not allowed to do that. You have to ask questions, so the objection is sustained.
You basically saw him.
Objection, he's leading.
Yeah, you have to ask questions. You can't lead.
Right. Did you see me write letters while we were at there?
Yes.
Do you know who those letters were written to?
Yeah, to the church people that you had that sent you the food box.
So you basically seen every letter that I...
Yeah, I'm going to sustain it. You cannot put words in his mouth. You have to ask him questions.
Right. Okay.
So that's sustained.
So you've never really seen me write a letter to Teresa Shoemaker?
No. Never.
It was always to one of my kids.
Yep. Actually, I think it was your son.
So basically, you're saying that we were basically...
Objection.
Sustained.
No further questions. Thank you.
All right. Cross.
Mr. Johnson, have you ever been convicted of felony in the past 10 years?
Yeah.
Is it 1? Is it 2, 3? Do you know how many?
Just one.
And what was it?
It was called, it was domestic violence when it first started. They worked it down to something else.
Would menacing by stalking?
Yeah, that's what they made that up. I mean, there was never no stalking or nothing. Me and my girl was together for the whole time.
But you either were convicted or you pled guilty to that and you were...
Well, I pled guilty to that to get a bond, personal bond, after being in jail for 5 months or 6 months.
Menacing by stalking, that's after being told to leave someone alone, you continue to harass them. That's basically what the charge is, correct?
She was the one that came pick me up from the jail, too.
Nothing else. Ladies and gentlemen of the jury, I told you when we started today that we would present testimony and evidence necessary to prove that this defendant violated a protection order on 4 separate occasions. He did this when he sent 4 separate letters to his ex-wife, Teresa Shoemaker. We're now at the end of the trial, and we have proven exactly that. The defendant and Teresa Shoemaker were officially divorced in July 2019. Due to continued contact and harassment, Teresa filed for a protection order prohibiting the defendant from having any contact in June of 2023. These are very simple, straightforward, irrefutable facts of this case. This defendant violated the terms and conditions of the protection order. This is a felony because this defendant has previously been convicted of this crime. As such, I'm asking that you find this defendant guilty of all 4 counts. Thank you.
All right, Mr. Shoemaker, you have the opportunity to make a closing argument on your own behalf.
The letters was written to my kids. Their name was on the outside, their name was on the inside. The only name on the protection order is Teresa's name. Her name was never mentioned. So, that's basically all I've got. Thank you very much.
All right, court's been informed that the jury has reached a verdict, and Mr. Link, you're the foreperson. If you would hand those to the clerk, please.
In the Court of Common Pleas, Highland County, Ohio, State of Ohio versus Alan W. Shoemaker. Case number 25CR124. Verdict, count 1, violating a protection order or consent agreement. Revised Code 2919.27A1. We, the jury, having been duly impaneled and sworn, find the defendant, Alan W. Shoemaker, guilty of violating a protection order or consent agreement as he stands charged in count 1 of the indictment. We further find that the defendant was previously convicted of violating a protection order or consent agreement as alleged in the count 1 of the indictment. All
right, then, ladies and gentlemen, first of all, the court will accept the findings of the jury and enter findings of guilty on each of the 4 counts that was set forth in the verdict forms. Now, ladies and gentlemen, that'll complete your service. I want to thank you for your service. And I'm going to step off, and if everybody would remain, please. All right. Anything from the state regarding sentencing?
Your Honor, we would ask for 4 consecutive sentences, as these are 4 separate events.
All right, Mr. Shoemaker, is there anything you would like to say on your own behalf?
No, sir.
Because this has been going on since 2019, and in trouble because of 2 things. Pen and paper. Yeah. The only person I know that seems determined to stay in prison. Because you've been convicted over and over again. 2019, violated protection order. 2019, breaking in, and I think that started out maybe as burglary. And then also menacing by stalking and violated protection order. So that's 2 violations. Failure to appear in 2019. 2020, violating protection order. There's 3. 2023, violating protection order. There's 4. All of these because you're writing and sending stuff to your ex-wife. No reason to communicate with her. You know that your kids don't live with her, but you continue to send her stuff. You want to try to stay in her mind. I understand that you have deeply founded religious beliefs, but that's no excuse for violating the law. In the eyes of God, as still married to this woman, that's fine. But, mental health evaluation, they said you finally admitted that in the eyes of the law you're divorced. So why would you want to send something to her? Why? There's just no reason. There is no reason at all, except you want to continue to harass this woman and to keep her upset.
Not harassment.
Well, you continue to do it. There's no other reason. You have no legitimate reason.
The Bible tells me I should.
No, the Bible doesn't. God doesn't tell you to violate the law and harass your ex-wife.
It says to be a watchman.
And you have no right to do that. And there's no doubt in my mind that the only thing that's going to stop you is death. And so it requires for her protection. Because quite honestly, one of my concerns has been over the last, because it's been going on for so long, is that you might finally get smart, quit doing it so you can get out. And then, my concern would be that you would cause her physical harm. But you continue to write letters, and you'll probably continue to do so because you can't stop yourself, or you won't stop yourself. So the only thing I can do to protect her is to make sure that you stay in custody as long as possible for these violations. Justifies the maximum sentence. If there was ever a justification for it, it's this case. This is not a TCAP case, which would require the time to be served in the county jail. So in this case, this time is to be served in prison. So it is the judgment order of the court that you be and are hereby sentenced on each of the 4 counts to the maximum term of 12 months. Now, as the court has indicated, this is with these 4 convictions, that brings your total 8 convictions for violating protection order, plus a felony B&E, plus a felony menacing by stalking, plus a failure to appear. And so your criminal history demonstrates that it's necessary to impose consecutive sentence to protect the public, and in particular, your victim, Ms. Shoemaker. The court also finds this a course of continuing conduct. 1 single prison term is not adequate to reflect the seriousness of your conduct. And the harm is so great because, again, this woman just wants to live in peace, and you won't let her. You won't let her. No matter what you believe under your view of God's word, does that justify harming her and ruining her, continuing to harass her? No. If you want to live in your belief, you're still married in the eyes of God, that's fine. Just don't say anything to her about it. Leave her alone. It's necessary to deter you from committing future crime and to punish you because, obviously the past sentences, and some of them were minimum sentences, some of them were mid-range sentences, it hasn't worked. And your release, if that ever happens, I don't know. Again, I'm not optimistic. It won't be my problem because I'll be long retired. But in any event, if you do get released from custody in the future, it is possible the Adult Parole Authority would put you under post-release control supervision. I certainly hope that they do. But again, that'll be up to them. It could be for a maximum of 2 years. That means you'll be supervised under the terms they set by a parole officer, and if during that period of time they determine that you have failed to comply, they can return you to prison to make you serve an additional period of up to 9 months for a single violation, up to a maximum of half of your prison term for all violations. However, to an additional period of a year, or whatever time is left on that period of post-release control, whichever is greater. All right, is there anything further, counsel?
There you go.
Do you have anything else, Mr. Shoemaker?
No, sir. No, sir.
All right, you're man into custody.
Judge, do you want him to sign this?
No.
Yeah.